I want to welcome you here today and thank you for coming to help us tackle this difficult subject. I want to emphasize that efficiency in this context, especially in this context, doesn't mean fast and careless. It means thoughtful and thorough. It means taking enough time to do the work, but not allowing time to pass without significant activity. We know our criminal justice system is not as efficient as it should be. Despite tremendous amounts of work by law enforcement, prosecutors, defense, judges, and others, cases keep taking longer and longer to resolve in Cook County. We've come here today to learn how we can do a better job. I want to thank Tom Wartowski, who's behind me, and Katie Welter, who helped put this forum together today and invited very impressive experts who were willing to talk to us. I want to thank Malcolm Rich of the Appleseed Fund for letting us have so much of Katie's time. I want to thank Loyola University, both the public policy and criminal justice departments, for sponsoring this event and allowing us to use this great facility. I want to acknowledge the American Bar Association for sponsoring this event as well, and thank our Kenwood Academy students for acting as ushers today. So Kenwood Academy is the public school that both of my children went to. Where are the Kenwood Academy young people? Come out and wave. Thank you. We're grateful to you. I can't acknowledge all the friends and colleagues that I see here today, but I want to recognize Justice Ann Burke. Justice Burke, would you please stand? She is a member of the Illinois Supreme Court. She chairs our Justice Advisory Council and deserves the credit for a lot of the good work that we've been able to do. We couldn't have done it without her leadership. Thank you very much.
In Philadelphia, we've long had a criminal justice advisory board, and I've been a judge for 24 years now, and I used to get tagged to go and fill in for somebody who was a regular participant. And it was kind of like those soap operas you used to watch in high school and college. You know, if you missed it for a year and a half, the plot hadn't really moved, that kind of thing. And about the time I became president judge, we pulled everybody into the room, and it's the chief prosecutor, the chief defender, myself, the president judge of our lower court, our police commissioner, our prisons commissioner, and our deputy mayor in charge of public safety. And I said, what we're going to do is we're all going to put our fingers in our pockets or in our ears, or if you prefer, up your nose, but no more pointing them at one another. What happens in the CJAB stays in the CJAB. And whether or not you do it in the context of that organization, which I strongly recommend, because once you do that, you will make amazing progress going forward. It really just makes it possible everywhere to begin to break the log jams, because it's always easy to blame. It's always the cops are doing this, or the liberal judges are doing that, or the defenders are delaying the cases, or the DAs are losing files in the... I mean, everybody has heard all the blame going round and round and round. Enough. It keeps the newspapers fed, but it's not doing a single darn thing for the justice system. So get together and resolve to just stop. And even when there is a foul-up, which there regularly is, particularly in large city jurisdictions, but everywhere, shoes drop all over the place. And the newspapers are just, you know, looking for blood. It's just so much better if you say, we're all meeting and we're going to talk this over and see what, if any, changes we need to make. End of quotation. And they'll try to push, well, what, shouldn't the DA have done this? And shouldn't the judge have, We're going to discuss it, and we're going to look to see what, if anything, we need to improve. If you can do that, you will see within 2 years an amazing change in your justice system. We've been doing several things because we're apparently on a mission to replace Marriott as a hotel chain with our incarceration rate. So within our Criminal Justice Advisory Board, we have a subcommittee called the Prison Population Subcommittee. And we're pulling all the statistics we can on everybody who goes in, how long they're there, why they're there, what's holding them. We also take like the top 20, the guys who have been there the longest, and drill way down. Sometimes they're in there for 3 homicides or something, and they're just going to stay there till things get wrapped up. But sometimes there's some lousy little case that's got the drain plugged, and you can get it moved along. So if you've got a prison, again, a prison population subcommittee with representatives from each of the agencies, although you don't need the police quite so much on that one on a regular basis, you can get an awful lot done. The next thing that happened was I thought it would be a lot of fun to be president judge. I thought I'd redecorate all my colleagues' offices. I'd take them out to lunch, I'd make little speeches, get invited to all the good bar association party. It's a 1 5-year term and out in Philadelphia, so I thought that'd be nice. And about 6 weeks into it, they pulled $15 million out of my operating budget because we get our city and county are exactly the same. And that is the source of our operating funds. And we got down to within 2 weeks of payday, and we had $10,000 left in the bank. And while the judges are paid by the state, everybody else in our system are row house people for whom missing a paycheck is catastrophic. So I knew that we really had to figure out how to generate revenue and how to save an awful lot of money. And everything that involves a piece of paper it's like a cow chewing up green dollar bills. We got very early got our civil courts entirely paperless. You can file while you're sitting home in your jammies in a snowstorm. You can pull up the dockets. You can do whatever you want. It took us longer to roll out our criminal electronic filing because we have to work with a state system, and, well, you know what it's like when you're working with the state and you're a mere county. You get all these roadblocks. But that's done, and in the meantime, for those of you who practice law, how many times did you go in a courtroom and can't find the file? And the witnesses are turning around, walking out, saying, I'm never coming here again. Police overtime is skyrocketing. One of the lawyers generally is very happy, and one of them generally is not, and the judge is unraveling. Well, if everything is in the computer, it doesn't matter if somebody ate the file for lunch. So just that is an enormous savings. And you're still going to be dealing with a lot of people who go, okay, we're going to create this document electronically, and then we're going to copy it. No copiers, no printers. And what we're doing now is working on a system where what we call our PARS reports, our police arrest report, is going to move instantly right through the system. Anything that needs to be redacted before the defense sees it, of course, that's very easy to do with computers, but long and short, within a matter of hours instead of a matter of weeks, you can have everybody in the system educated as to what the heck this case is about. People forget that defense attorneys can't even begin to talk to their clients about pleas unless and until they have some idea what it is they're charged with. So with that moving through the system, I'm kind of thinking that my last act when I end as president judge will be to issue a decree limiting how much paper everybody in the system can buy. But when I started, we were spending $600,000 a year on toner for copiers and printers, and it was making me nuts. So that is really underway. It's saving us huge amounts of money, and lawyers will pay to be users of the system. On the civil side, you can add all kinds of charges on, and they don't blink at all. They pass it on to the clients, and it's terrific. On the criminal side, they will pay for things like using our interactive video setups to interview their clients so they don't have to go out to the county prisons and all that kind of thing. So in that area, our only big, I guess, hurdle left to overcome is, I don't know how it works here, but our appellate courts still make us print out the whole record and everything else, and lots of copies before we send it to them. So I'm trying to get that finished as well. The other big thing that you can do is come to find out that in a lot of ways, at least on the criminal side, we don't know what we're doing. I've been sentencing people now for 23, 24 years, and we have a sentencing guideline system. I think a lot of states do now, and the vectors are the seriousness of this particular crime and what their prior criminal history is. Well, that makes sense. That sounds like the guys who score high on both of those are your bad actors, right? No. As it turns out, we were able to partner with the University of Pennsylvania, and it took years until there were enough really powerful computers, and they collected about 20, 25 years worth of data and just put in as many fields as they could think of. And it turns out that the single strongest predictor of recidivism is the age at which they first enter the system. Now, all of us do kind of raise an eyebrow when somebody's been in the system since age 12, but who would know that that's how important that is? So when we began doing that, and again, this was part of why we were being pressured so much, because we lost a big chunk of our operating budget, which meant a lot of our probation officers and pretrial officers. We were able to shift our whole probation system so that you think of it as a triangle, pyramid, like that food pyramid that they keep shifting on us, and an awful lot of people at the bottom, significant majority of the whole lot, are people that you put them out awaiting trial, or you let them out after on probation after the trial, and you say, go forth and sin no more, don't let me catch sight of you. And they stay below the radar. They do just fine. And then there's a chunk in the middle, and again, using all these predictive factors, where we have to kind of dope slap them a little bit every now and then, but you can manage them. And then there's a teeny bunch at the top, and these are the kids where we need to spend all of our time and our resources. Our goal for them, it's just pathetic, but our goal is alive at 25. And that's how endangered these children are, and it's mostly children, of either being shot or being shooters. So we have, for them, officers out 24/7. And when their friends get arrested, they're there because they know they've been hanging out with their friends. They know where they live. They know who they hang with. They find out when they're not going to school, all that. But you can't concentrate on those people who really need the concentration unless you've been able to make the decision to release the degree of supervision further down the pyramid. And it's really worked well. We've not had a disaster, and you can all imagine how that can happen. And it probably will at some point. Somebody that we thought was a low risk and was by all means a low risk will do something to send us over the moon. But so far it's working, and so our state sentencing commission has now taken that model and moved it to sentencing to try to come up with not a replacement for our sentencing guidelines, but basically a three-level risk assessment for recidivism. Very low risk, moderate risk, high risk. And they're expanding that. You know, you always start with the low-hanging fruit, misdemeanors, that kind of thing, and move it up. And hopefully that will make that very nerve-wracking job of trying to predict future behavior a lot easier, but it also allows you to use your resources where you really need to use them. And none of us going forward has, I think, the resources to spend them where it's not absolutely necessary. So
I came into the state's attorney's office in Winnebago County in 1986. I'd been an associate judge for 6 years before that. When I met Governor Edgar for the first time, he said, "You're the guy that was a judge and became state's attorney? What's wrong with you?" But I made the move into the state's attorney's office, and I inherited a federal class action lawsuit in front of our federal judge out there, Judge Ruskowski, involving the overcrowded conditions in the jail. Now, our jail and our process is of a different scale, obviously, than Cook County, but it is nonetheless equally challenging to a system. Our jail was built in 1975, built to house less than 300 inmates. From the day it was built, it was overcrowded. When I took over the state's attorney's office, we were pushing 500 to 700 inmates in a jail that was designed to hold about 290. We were able to put more men and women in that jail without adding any square footage. We simply converted gyms to dormitories, and we converted every possible space, and we doubled and tripled bunk cells, and it was not a nice situation. We made some efforts. We got the first lawsuit dismissed. I thought we were doing very well, and things started to heat up again, and we had a second lawsuit filed. So I find myself in a position that was very much a challenge. As a prosecutor, your job is to take dangerous people off the street and confine them, process their case. The ones that get a second chance are released back into the community with conditions, and the other ones are sent away for a period of time. Some are sent away for a very long period of time. But it became very clear that we really had to look for efficiencies in the system if we were going to manage a jail population. In the meantime, we were trying to pass referenda to get additional revenue so we could build a new criminal justice center. And finally, we got that passed, and the month after I retired in 2007, they opened up a 1,200-bed facility. I never got to enjoy that facility. But what we did was really, I believe, a true search for efficiency using a very collaborative approach. And now, just so you know, in my encore career, after 30 years at the courthouse as state's attorney and judge, I now head up our local United Way. So now I preside over a system of human services, and I'm learning a whole new jargon. Things like common goals, shared strategies, strategic collaborations, collective impact. And what I've discovered is that many of the things I'm talking about now in the area of human services and transforming communities and altering human behavior were things that we did rather by trial and error within the criminal justice system. My goal was to manage the jail population. I did not want to be held in contempt by the federal magistrate. Neither did I want the federal court to actually move in and take over administration of the jail. Frankly, that would have been easier if the federal court had come in, appointed a receiver, and said, okay, run the jail. But the federal court did not do that. They kept giving us the opportunity to manage our way out of the situation. My first clue that something had to be done was to get involved in the system as the chief prosecutor and to realize just how incredibly inefficient we were. That there was a problem getting information to the decision makers. There was a problem with everything from lost files to the lack of a copier machine in the courtroom. I took a trip early on in my time as state's attorney, and I was visiting a friend out in Marin County, California. And I took a tour of the courthouse in Marin County, which is the only courthouse in the nation that's designed by Frank Lloyd Wright. And I went there to admire the architecture, and I went through the DA's office. I had a sheriff tell cousin in the DA's office, and I noticed a sign on the door of one of the assistant district attorneys out in Marin County, California, and it said expediter. And I turned to my cousin, who was an assistant DA, and I said, "What the hell's an expediter?" He said, "That's a lawyer that doesn't have a trial caseload. That's a lawyer that gets the cases, and cases are assigned to his unit that the senior attorneys look at the case and say, this case is never going to trial. This is a dead-to-right burglary. This is a probationable case. It may be a 4-year minimum prison term, but it's going to be predictably a case that will probably not go to trial, highly unlikely to go to trial. Therefore, let's not throw it in the courtroom with the trial attorneys. Let's keep it in this expediter unit. Let's speed up discovery. Let's get discovery to the defense as quickly as possible. Let's get as much of the information we need to make decisions. Make an offer within 2 or 3 weeks. Make an offer before it goes to grand jury. If you don't have an acceptance, we'll go to grand jury. We'll get an indictment. But we still keep talking. We set up what we call the pretrial unit, one of our first efficiencies. That was assisted by the fact that I worked with my court services, my probation department. I said, we need more information, we need it quicker. They assigned people to go into the jail every day, talk to the newly arrested, and get as much information as possible in terms of prior record, any mental health problems, any addiction problems, contacts, family, jobs, what their history was. And what we found was we were making much better bond and bail decisions because the judges had much more information. More people were being released because judges had more confidence that the people they were releasing had good community ties. We had more information to them. In the meantime, my pretrial unit was expediting their offers, getting discovery to defense lawyers more quickly. In the meantime, we also convened a jail committee. It helped that I was an associate judge before I was state's attorney, and I walked easily among the judges. And we were able to get the public defender, the state's attorney, the chief judge, the presiding misdemeanor and traffic court judges, the court services department, the circuit clerk. I agree with the president judge that we didn't have the sheriff or the chief there. We did have representatives of the sheriff's department there as the people that run the jail, obviously. But in terms of the arrest part, that was something that we really didn't worry about, except to put pressure on the departments to get the reports to us quicker. I put resources where we had the problems. More people in the case screening. We avoided filing charges when we didn't have complete reports. When the case didn't justify it, we wouldn't file. That was rather remarkable because a lot of prosecutors' offices simply take the arrest and kind of rubber stamp it and file the charge. We said we're not going to do that. We increased information to the courts on bond decisions. We increased the resolution of those cases to our so-called expediters. We resolved almost 90% of those cases within 90 days. Never went to a trial lawyer, never tied up his desk, never tied up a courtroom. We had those cases resolved. As the judge said, you know, the murder cases and the sexual assault cases, the armed robbery cases, those are kind of the easy ones, you know. They're going to stay in jail. Okay, we're going to work those through the system. We can't really talk about a lot of pretrial release on those serious cases. The petty offenses, the traffic cases, the misdemeanors, those are kind of the easy ones. We're going to move those people out. Recog bonds, low bonds, they're going to find their way out. It was those massive cases in the center. The Class 3s, the Class 4s, maybe some Class 2s, the drug offenses. Those were the cases we would meet on a daily basis to look at and say, okay, who's a risk, who's not a risk, who are we going to move along, how can we move this case through quicker? And that was really the system that met. At no time did any of us compromise the sense or the principles of advocacy. We represented our client, the people of the state of Illinois, and the public defender and the assistant public defenders represented their clients to the utmost. But the one thing that I did do, and then I'll conclude my remarks, early on in my tenure, and at that time I was on the faculty of the National College of District Attorneys, and I used to teach ethics to prosecutors all over the country, and I used to, in part of my presentation, I'd look up cases all over the country involving prosecutorial misconduct, and some pretty egregious cases. And after about 5 years of teaching those ethic courses, I had the entrance to my office redone, And right on the inside wall, as my prosecutors walked into the office, I had gold letters. They weren't real gold, they were plastic, but they looked nice. And what I put on the wall, and my prosecutors every day had to walk past that wall and read what was on the wall. The duty of the prosecutor is to seek justice, not merely to convict. Those are the first words from the ABA Standards of Criminal Justice for prosecutors. And part of this way of moving cases through the system was giving my assistants the discretion to exercise judgment regarding the cases. And if they believed that justice was best served by a dismissal or an amendment of the charge, they had to feel empowered to do that. And to make them comfortable doing that, we encouraged them to talk to senior attorneys, bounce it off them, bounce it off me, and to make the right decision. But never did we compromise the advocacy on behalf of the people of the state of Illinois, and I don't think anybody else in the system compromised advocacy. We simply came together, worked together, got information, and made better decisions, and we moved cases along faster. And my goal was to reduce jail population, and we did. We brought it down from an average of about 600, 700 inmates to, by the time I was done with the same size jail, we were down to between 300 and 400 inmates. And it was all due to efficiencies. In the meantime, our commitments to the Department of Corrections increased, and the crime rate actually came down a little bit. Justice can be done under these circumstances, but it's just moving the cases, I think, faster and more efficiently and with better information.
I must admit, when I heard the title, Justice Through Efficiency, I was a little anxious. As a defender, when I hear words like efficiency, I think of assembly line, case processing. And over the years, I've sat on a variety of committees designed to reduce the time that cases flow through the system. But I do agree that justice delayed can often be justice denied. And I recognize the importance of balance as it relates to efficient, effective, and equitable administration of justice. I want to point out just briefly that the idea that sometimes slowing down can be more efficient in the long run. Recently, I was talking to a former student, a young defender on the West Coast, about her training program covering the initial client interview. And the trainer inquired of the students whether they were rushing the interview because they were so busy. Their caseloads were so high. They had other tasks, other duties, instead of slowing down and engaging the client and establishing a relationship. And the trainer's point was that sometimes making and taking time is more efficient in the end. Because as defenders, we know that when hard decisions have to be made about pleas, about trial strategy, the attorney-client relationship is critical in plea negotiations, etc. Also, if you can take that time to slow down, to treat the person like a person, develop a relationship, you're going to cut down on claims of ineffective assistance of counsel later on, wrongful convictions, appeals, etc. So the idea that efficiency may be counterintuitive and have unintended consequences, as I'm sure comes up at many phases of the criminal justice system, and we'll discuss it as we go forward. So let me talk just briefly about two programs. One, the Criminal Defense Consortium of Cook County, which was established in the 30 years ago. I was just a baby. And the idea was we had 6 neighborhood offices: Woodlawn, Uptown, Westtown, Harvey, Evanston, and Lawndale. 4 lawyers, an investigator, a social worker, and 2 secretaries in each office. We had a community board around each office, and it was an experiment. It was put together by the Department of Justice. At that time, they were interested in trying to figure out how public defender offices could be more efficient and effective. The idea was that the lawyers in that office would work closely with the social workers, so we wouldn't just be concerned with the legal case. Of course, we were concerned with the legal case, But we also wanted to figure out what brought the client to us in the first place, and how we could keep clients from coming back, and what we could do in terms of aftercare after the case was over, what we could do in terms of putting resources together to solve the collateral consequences of people being involved in the system. And it's sort of a precursor to what we see now across the country in terms of client-centered representation, holistic representation, community-based representation, the idea that we have to have a community of folks involved. And then we had people from the community connected to each office to talk about their perceptions of the system of crime and justice and what we could do to ameliorate some of these issues: housing, employment, mental health issues, drug treatment, children and family issues, etc. So I want to fast forward to today and talk about a public defender's office in D.C., the Public Defender Service of the District of Columbia. And if you look at that office, it kind of puts together some of the elements that we were talking about in the Criminal Defense Consortium 30 years ago, 40 years ago. The office has a Defender Services Division, which is designed to provide the private bar as part of the delivery of indigent defense services. So the Public Defender's Office may handle 30 to 40% of the cases, but the private bar is involved either on a pro bono basis or on an appointed basis to handle the rest. Therefore, the public defenders can have reasonable caseloads. There's an Offender Rehabilitation Division, staffed by social workers and others, designed to do the same thing that the consortium did. And by that I mean provide collateral service dealing with collateral consequences of conviction. So, you know, the typical case we'd have as a public defender, atypical maybe, a client arrested, in jail, locked up, losing her job, losing her apartment, getting evicted because they can't get out on bail. The typical public defender's office is not equipped to deal with that. But in some offices where you have the resources, you can bring in the private bar to deal with some of those civil consequences, either on a pro bono basis or on an appointed basis. So those are two programs that are kind of counterintuitive in terms of what you think about efficiency. But if the idea is to be cost effective, to reduce people rotating in and out of the system, to provide solutions to crime, then we have to think in a more comprehensive manner. I want to talk just for 1 or 2 minutes about race, racism and racial disproportionality or racial disparity, because as much as we'd like to, when we're talking about the criminal justice system in major urban areas, we can't avoid talking about race. From arrest to charging to bail decisions, pleas, trials, sentencing, and incarceration. And of course there's a difference obviously between racism and racial disparity, and we have to be careful and precise when we have these discussions. Sometimes when we talk about criminal justice policy and its impact, we have to be aware of the racial impact. Sometimes the consequences are unintended, and there are numerous examples of this, you know, the crack cocaine disparity, the use of automatic transfers to move children out of juvenile court to adult court, etc. But we have to make sure that we discuss how race impacts criminal policy and how criminal justice policy impacts race. This month, you know, in every talk that I've given a few, I always want to mention that this was the month that Martin Luther King wrote his letter from the Birmingham jail. And the famous statement that we are caught in an inescapable web of mutuality, tied in a single garment of destiny, beautifully written sentence, but it's an excellent description of what we're involved in the criminal justice system, as our previous speakers have pointed out. The actions of one institutional player affects the rest of us. When the police engage in mass arrests or increased arrest, that obviously affects the courts. When the prosecutors do not engage in appropriate discretion in the charging process, as our previous speaker pointed out, that affects everyone. When they are pushing for mandatory minimums and enhancements in every case, that affects the public defender's caseload. It affects the jail population, eventually the prison population. When judges refuse, for whatever reason, to set reasonable bails or appear to favor the state as opposed to being impartial, the justice system suffers in terms of efficiency and effectiveness. So in thinking about efficiency in the context of the criminal justice system, we do know a few things, right? Research and common sense tells us a few things. We know that prevention is more cost effective than incarceration in terms of human and economic costs. We know intervention and diversion is more cost effective than incarceration. We know that incarceration should be used as a last resort, as was pointed out by a previous speaker. We need to be less punitive and more thoughtful. Treatment, diversion, rehabilitation, re-entry programs are cheaper and more effective, and we cannot lock up our way out of this problem. We're now #1 in the world in terms of our rate of incarceration, with less than 5% of the world's population, but 25% of the world's prisoners in the United States. Hopefully this program can get us on the way to start thinking about ways in which we can be more efficient, more effective in improving our system of justice. As the judge pointed out, we have to be careful about pointing fingers at each other, but instead must look in the mirror and ask, what can we do? And when I say we, I mean state and county officials, judges, prosecutors, defenders, and law enforcement. What can we do in our own lane to improve the quality and perception of justice? And at the same time, we have to recognize that we are tied together, albeit with different perspectives and different responsibilities, in an effort to achieve the quality of justice that our community deserves.
I guess I get to represent the law enforcement side of things, and as the spoken, maybe I do, or I, being the representative of law enforcement, kicks things off and starts this whole process, and sometimes my efficiency and effectiveness may cause issues with the court and issues with corrections. I'd prefer to look at criminal justice as a investment and not as a cost. I'll give you an example. Aurora had a bad reputation. Still, I think he has a bad reputation. We had 26 murders in a year and about 357 shootings. Aurora is about the size of a district in Chicago. So if you do the math, it'd be about Chicago having 656 murders in a year's time. So just to put it into a little bit of a scale. We dropped that to 0 last year. It's the first time since 1966, or 1946, 66 years since Aurora had 0 homicides in a single year's time. A couple days ago, thank you. That is huge, and I appreciate the applause. And we'll get into the community and the police department, the efforts that we're taking to get there. Other than about less than a week ago, we had our first gun-related murder in almost 2 years. If we got to June 8th, we would have not had a gun-related murder in 2 years. So we fell about 23 and a half months of no gun-related murders. The reason I say that's an investment, that people wouldn't come out to Aurora. Paramount Art Center is a nice place downtown. I'm a subscriber. Go to those different plays and different things that they have there. About 85,000 people in prior years would go. In 2012, 200,000 attended. $50 a ticket. I don't know. My wife always pays bills, so $50 a ticket. That's $6 million added to revenue because of decreased crime, increased other things that are going on in the city, and people were willing to make an investment in the city. it just can't just happen overnight. It has to be sustained. If you look at the prior couple decades, Aurora would average a little over 16 murders a year. In the last 5 years, we're averaging about 2.5 murders a year. Dropped our shootings from 357 to 59. Out of those 59, 12 people were hit by gunfire. One person was seriously injured, but obviously survived his wounds. There's a lot of things talked about already about efficiency and effectiveness, and I think that's very good. We took a comprehensive approach, and as my colleague had talked about, the police department is never going to arrest ourselves out of this situation. We had to have some very good partners and get that process going. How we did that is a number of years ago we decided that it's very difficult to get community involved when the community is not feeling respected, trusted. Police had this idea that we're going to do it for you and not with you. So we had a lot of work to get that trust built. We had work to get that respect built up. And so we decided that we would go with drug cases and stealing a play out of the federal agencies, going after Al Capone. Didn't get charged with anything relative to his violence. He got charged with a lot of crimes relative to his racketeering or his tax evasion. So we took the same approach. We arrested about 200 people in various sweeps and put those individuals in jail for long periods of time. But at the same time, we took a community policing approach. So as we're taking individuals off the street through arrests, the community is also recognizing that the police were serious and really started helping us out. We partnered with Aurora University. We started a program called My Time. So once a kid gets out of school, whatever into school was for that particular school, I have 5 school districts, so each one's a little bit different. They would have a mentor and a tutor till about 6 o'clock, and then go with their parents. So that was huge. East Aurora High School had a big problem. Most of our gang problem and drug problem was on the near east, near west side of Aurora. So a lot of those individuals go into East High. And East Aurora started a junior ROTC program. It's now the nation's largest junior ROTC program. Nearly 1,000 kids are going into that school. So when you think about kids not wanting discipline or being antisocial, if you look at a gang manifesto, try to come to a school or a meeting late. You're going to get a 30-second beat down. Try to get out of the gang, try to get into the gang. There's all these rules. So their kids are not looking for no rules. They are looking for that discipline. And so it's really thriving in that area. Boys to Men was another program that was started by the Urban League, and really showing young men how to be a gentleman, how to be an adult. And that really has taken charge as well. So at the same time, we're doing a lot of enforcement. We're also backfilling with very good relationships and partnerships with the city and with the school districts, coaches, a lot of different places. Along the way, we added a number of efficiencies. Somebody had said something about the state agencies. Illinois, you wait a long time for fingerprint evidence. You wait a long time for DNA evidence. So we invested in my own AFIS machine, automatic fingerprint identification system. So instead of waiting 8 to 12 months for returns and having an individual create a lot of crime in that time frame in order to get arrested and dealt with, we have our own. So now it's what used to take 8 months to 12 months now takes less than a week. Leads Online, it's a process where you have to register your pawned and recycled items. In the first 7 months of that program, we had 35 additional arrests for burglary and theft because of that program. Create a lot of different partnerships with the federal agencies. Made a number of organizational changes. I have there's 289 sworn, 235 are at the officer rank. Of those 235, everybody works either the street or detective unit. Only 2 work in an administrative position. So there's less than 1% of the staff work in some kind of admin function. The 2 are a range master and a training officer. They're the only 2 exceptions. I think it's important to make sure that, like I said, the community is involved. and how they can help you and those type of things, which we made out very well. Community, or the impact on criminal justice, obviously when we're making those arrests, it's going to have a big impact on the courts and then the corrections, putting those individuals away. I talked to our state's attorney, and he sent me the numbers just before I started today. And when we started, his caseload started going up and up and up, and he had a lot of cases, huge increase, probably increased by better than a third. Last year, it probably decreased by more than a third because, not to say all the bad guys are gone, we still have work to do, but there is a big change in what's going on with that impact. Going on after the courts, obviously, a lot of conversations about corrections and making sure that people have a place to stay if that's where they're best located. I'm currently looking at a program out of Charlotte, North Carolina with a GPS system. And one of my colleagues talked about who belongs in prison. I saw two things in that program that really struck home. 88% of the individuals that had a GPS on them did not reoffend. And I thought that's a good percentage. He had 12% of them reoffended. So even with an ankle bracelet, GPS, active GPS, where somebody's watching them move around, they, for whatever reason, whatever motivator they had, whether it was drugs or sexual addiction or whatever the case was, they could not stop themselves, and those are probably the individuals that we need to be incarcerating. So those are some next steps. And a lot of different things going on. Again, we really looked at taking the prolific offender off the street. Some people call it Pareto rule, the 80-20 rule. England came out with a big study that said about 6% of your offenders are responsible for 60% of your offenses. So go after those 6% offenders, and crime will really turn around. Crime in Aurora dropped about a third, Part 1 crimes in the last 5 years, and I gave you all the data on the shootings and the sustainability of those shootings. One of the Catholic priests in the town, Father Ingbarth, had talked about a crime, and he was very upset. He said it was a time when he had just done one gang funeral and was doing another one, and his life was threatened. So he did the funeral mass in a bulletproof vest. And he said that that was one of the worst times in his life, not because of the crime and not because his life was threatened, because every time he turned around there was another shooting. 357, that's one a day. And the city of Aurora is 200,000 now. Back then it was probably about 140,000. So that is a big thing. And he went on to say that every time he's turning around, shootings. There was such a loss of hope, and even in God's house there was no sanctuary. That really hit home for me, and I'm glad to say that his prayers for having a homicide free were answered. So, thank you very much.